Hello everyone, welcome back to LW1230 Business Law in Canada. My name is Paul Tilley, and this is Unit 1, Part 4. Today we're going to look at some regulatory bodies, courts, and some cases.
Now, the court system, if you imagine all of the people in Canada who could find themselves in a situation where they want to sue someone, or a business that wants to seek redress, or someone who wants to seek redress for business, you would clog up the system, for every little thing. So one of the things that government has done is they've kind of set up what's called regulatory boards. And a regulatory board is meant to keep some people out of court for, I'll call it, common things. So government departments establish these regulatory bodies, or sometimes they're called administrative tribunals, such as labor relations boards, human rights commissions, workers' compensation boards, to implement and enforce their policy. So let's say, for example, you apply for workers' compensation, you're denied. Okay, so you could go and sue for that, or it would be more effective if the labor relations board had some sort of an appeal body. And that's exactly what these regulatory boards are supposed to do. They're supposed to take the pressure off the court system by helping solve problems before it actually goes to court. So the bodies may look at the act and may look and act like courts, but they really don't have the power that a court has, and so they're somewhat limited. But these administrative tribunals nonetheless make decisions that have a lot of impact on people, a lot of impact on businesses. And if the business feels that that power was abused and they were not treated fairly, they thought that something went wrong, they can appeal to go to court with it. So the regulatory body decision could be appealed to the courts. Okay, the whole idea of the regulatory bodies is to keep people out of the courts. So to determine our rights before administrative tribunals, there are three questions that must be addressed. From where the tribunal derive its authority. So, for example, the Labor Relations Board has a Labor Relations Tribunal, and in legislation, it outlines what the authority of that tribunal is. Was the decision-making process fair? And if, for example, the decision process could be argued to be not fair, for example, the decision maker was the brother-in-law of the, that sort of thing. What recourse is there if there's been some failure in procedure or jurisdiction? And the recourse really is to the court system. So the courts ultimately can review. So to protect the public interest, courts are empowered to review tribunals. Okay, so there's not a lot there on the tribunals. I just want you to make sure that you're aware of them. What I want to do, though, is to focus a little bit more on the Newfoundland court system. And if you go to the webpage for the law courts in Newfoundland, you will see that there are three of them listed out. The one on the right, the provincial court, is your court of original entry. That's the first entry-level court. Okay, that's where you end up going if you got something that you want to contest. And the one on the left, the green one, the Court of Appeal, that's the one you end up going to if you you want to appeal a decision. And so that, this kind of situation is the multi-levels of the courts. From a federal level, if, for example, you ended up in bankruptcy, or if you committed a federal if you're federally regulated, let's assume that you're an airline or something like that. So you're a federally regulated business, you would end up in court here. It works much the same way as the provincial courts. But again, federal courts' job is to hear legal disputes arising in the federal domain. Lawyers will determine which of the courts you go to. Usually a higher, larger businesses will probably end up in federal court because they cross provincial boundaries. Again, I have this court hierarchy, and you can see this is more or less an upside down hierarchy. Okay, the bottom level, or the court of originals, are right up at the top. So the federal boards on the left, provincial boards on the right. The various levels of courts, the federal court, provincial court, goes up through the Court of Appeal, which goes to the Supreme Court of Canada. So what I wanted to do this morning then, if I want to employ some of this stuff, so I think there's 3 or 4 cases there. There's four, I believe. Yeah, 4 cases. So let's just look at these cases. And I want you to think about these from what we've discussed here in this course so far. This is an interesting one called Isnts versus Sims. Now, Isnts was the plaintiff, Sims defendant. SCC stands for Supreme Court of Canada. 2006 is the date, and the file number is there attached to it. Now, Isnts was the owner of a 17-foot pleasure boat. After a day boating on the lake and loading the boat on its trailer in preparation for transporting it to the highway, Isnts was securing the boat with the help of Dr. Sims. Isnts was stretching a bungee cord over the engine when it slipped and hit Dr. Sims, causing an eye injury. He and his wife sued in the Ontario Superior Court for $2.2 million. Mr. Isnts brought an application before the federal court for a declaration that the federal maritime law applied, and the Canada Shipping Act imposed a $1 million limitation on damages in this situation. Explain whether the limitation imposed in federal statute should apply. So here we got a situation where you can see a couple of guys, you can see this happening, okay? And every time I use a bungee cord, I think this could happen. This is a worry that I have with bungee cords. They got the boat up on the trailer. They're trying to put a couple bungee cords on the motor. The bungee cord slips, hits the doctor in the eye. Okay? Problem for the doctor. The doctor sues. I imagine the man would have insurance. He's going to go after his insurance company. And he goes to the Ontario court. Okay? The Ontario court has no limits on how much you can sue for. So he sues for $2.2 million. The other guy, the guy who owned the boat, said, hold on a minute now. I really think that this should go to the federal court. And the federal court imposes a $1 million limit on that limitation. Now, you ask, why? What's the dispute over jurisdiction here? Why federal? Why provincial? And the reason is because a boat. It's a boat. So the boat would be on navigable waters, and navigable waters are what are defined as federal jurisdiction in Canada. Okay? Federal jurisdiction. So his argument of the Canada Shipping Act would be that it's a boat, it's dealing with a boat, it should be tried in federal court. Explain whether a limitation imposed by the federal statute should apply. So, anyway, so you can imagine this going to court. Now, obviously, this case has implications nationally because we can see other organizations or other cases of similar thing happening where someone gets hurt and they sue, and we're trying to determine which jurisdiction it is in the case of navigable waters. Okay? So what had happened then is this ended up going all the way to the Supreme Court of Canada because it had this nature to it of the nature of a court case that had implications far beyond. So the Supreme Court of Canada published all of its cases, and if you search this case, this is what you'll come up with. And in the Supreme Court page, they outline what they found. So I'm just going to scroll down through it to show generally how much of a ruling you get when you get a ruling. So Isnts versus Sims, 2006, the number on it, report, case number. Look at all the judges that had to go at this, right? So this is the judges on around the Supreme Court of Canada, good number of them. I think there's 13 or 12, one or the other. And the subjects is constitution law, i.e. the jurisdiction that it occurred in, and maritime law, the boat issue. So you can see when the judges rule on it, and the Supreme Court is interesting because there's multiple judges on the Supreme Court, okay? So that means that they all get to take a crack at it, and their job is to agree. So we've got these judges here writing this. So here we go. This is all of the gear in that judgment. So we talked about there a little while ago, the judgment that the court brings. Here's the written judgment, and you can see that there's a lot to it. It's not just, here's the decision. There's a good rationale. So let's just go hunt down through this. The start of all of these outlines exactly what that little case that I just read about outlines what happened. Okay, what happened, and it also notes why these areas of law, or particular areas of law that we're looking at here. So in this case, maritime law, there's a pleasure craft and there's a liability limitation. Boat being prepared for transport on highway, boat owner using bungee cords, plaintiff suffering personal injury, plaintiff bringing action, whether limitation of liability provision contained in federal shipping legislation is applicable is the question that's being asked, right? That's what they need to determine in this Canada Shipping Act. And the Canada Shipping Act is referenced right here. You can click on it and go to it. In terms of the Constitution law, what we're worried about is where does this fit in terms of constitutional responsibility or jurisdiction? So division of powers, navigation and shipping, scope, pleasure craft, boat owner using bungee cord secure cover, plaintiff suffering personal injury, plaintiff bringing action damages against boat owner claiming benefit of limitation of liability provision contained in the Federal Shipping Act, whether the matter is governed by federal power over navigation and shipping or provincial power over property and civil rights. So there's a little story. So it was held, in other words, the Supreme Court of Canada were introduced this, they were told this basic information, and the Supreme Court first decides, should we take the case or not? So the appeal should be allowed. So they did accept the case. They go through here a little bit of blurbage on the various relevant, according to the Canada Shipping Act, it's not constitutional applicable in this case, and I cannot claim the benefit of the Limitation of Liability Act. That's what the situation was there. While Parliament's jurisdiction over navigation and shipping pursuant to the Constitution Act includes tortious liability of owners of pleasure craft for negligent launching, the mere involvement of a pleasure craft in the incident is not sufficient to grant federal jurisdiction. Now, why is that? Why did they say in this particular case that it's not federal jurisdiction? Well, it happened on a boat, but the question is, where was the boat? And if we read the case carefully, we'll notice that the boat was on the trailer. It was not in the water. So what the court decided was this boat is not in the water at the time the accident occurred. So as a result, it is not acting as a ship, or, it's not floating. So the Canada Shipping Act does not apply to it because it's on land. It should be provincial jurisdiction. Therefore, the law concerning the standard of care for the liability should be applied to other users of Ontario roads who make preparations to transport. In other words, it was deemed to be provincial jurisdiction, and as a result, the $1 million limit was not applicable in this case. You'll also notice we talked about earlier on the fact that we live in a common law system. The whole common law system works on precedent and past cases. Well, the judges in this case cited previous cases, and you will see cases cited. Whitebread versus Wally, okay? And there it was dealing with what's applicable in terms of the Shipping Act, okay? That's what that case dealt with. They also may have looked at other cases.
Paul?
Yes.
Would it make a difference whether it's a boat for pleasure or a boat for business?
No, the real crux of what this case turned on was the boat was no longer in the water. So it really wouldn't matter if the boat was a great big, could be a 5 million ton ship. If it wasn't in the water, it's up on land. So the court ruled that because it was not in the water and it was on the land, it would be considered a provincial jurisdiction. So, these are the permutations that judges have to worry about. And they got to read the law so carefully. And you could say, well, that's splitting hairs. It is. A lot of these decisions do split hairs in order to be able to determine whether or not a certain jurisdiction is responsible or certain liabilities. So you can see that these judges then look at other cases. They read the Canada Shipping Act, word for word. This is where legal wording is so important. And the provisions of the various acts. And at the bottom of the case, it gives us, for these reasons, I conclude that the alleged negligent act giving rise to Dr. Simpson's injuries is governed by provincial law. Now, the next case, Ramsons versus Peterborough, the city of Peterborough. Okay, in this particular case, this is a classic case dealing with freedom of expression. So we saw in the Canadian Constitution, it clearly lays out that an individual has the right to freedom of expression. Okay. City of Peterborough had passed a bylaw prohibiting the posting of any material on city property. The bylaw prohibited the posting of any bill, poster, or other advertising of any nature or any tree, pole, post, stanchion, or other object within city limits. Ramson put up advertising posters on several hundred poles to advertise the upcoming concert for his band. He was charged with committing an offense under the bylaw. It is not disputed that he posted the bills on the poles, but indicate what other defense he might have for the charges. So what do you think? Okay, you can see that happening in Claremont. I can see council making a rule and someone putting up a poster. What would be, we know what the city or the town's perspective on it. Don't put, we understand the rationale, or we should understand the rationale for why the town didn't want that sort of thing, because it clutters up the street, clutters up. But what would be his argument, Ramson's argument? Why would he be allowed to do it? Why would he argue he'd be allowed to do it?
Something to do with freedom of expression, I would assume.
Yeah. The Constitution guarantees us as individuals, Canadians, the freedom of expression. So he came up to the court and he said, look, you are violating my freedom to express myself. The city cannot limit my ability to put up these signs. And this, this is a real conundrum that you would find yourself in if you had to, as a city officer, you have rules that you want people to follow. You don't want stuff up on poles. I know it's a bad problem in St. John's, not so much a problem here. And, the question becomes, wow, is this legitimate? Should we allow this? And are we really infringing on people's right for freedom of expression? Beyond just an individual putting up signs, it's, can a government, a city government or a provincial government or a federal government limit your ability for freedom of expression? So this went.
So what if you're trying to find your pet in that city? Yeah,
well, it doesn't matter. That doesn't matter what you put on the sign. The fact is, you'll argue that as a freedom of expression. So here is the case as it was determined in 1993. And you can see that in terms of the legal concerns here, the Constitution Act, Charter of Rights, guarantees freedom of expression. So this is what we're looking at in the municipal bylaw banning the posters, whether postering is a form of expression, and if so, whether it's protected under the section of the Charter, or if it's an infringement and that is justified under the Charter. The appeal concerns the constitutional validity of municipal bylaw prohibiting all postering in public property. The issue was whether the absolute ban on such poster infringed on the Charter guaranteed them freedom of expression, and if so, whether it infringed if the infringement was justified. Now, it does say in the Constitution, right up at the top, it says, all rights are guaranteed provided that they are reasonably justified in a free and democratic society. So we get in some explanation. The accused advertising upcoming performances of ban on 2 occasions by affixing a poster at hydro poles contrary to the bylaw. On both occasions, he was charged under the law. The accused, while not denying the offenses, took the position that he had the constitutional right to do so. The Justice of the Peace found that the bylaw did not violate the charter and convicted the convict was he was convicted. He was convicted. The appeal to the provincial court. So there was a Justice of the Peace. So this is like a board, like I'll call it a city board. The appeal then went to the provincial court, which was dismissed, was based on agreed facts that postering on utility poles could constitute safety hazard to workers climbing them, a traffic hazard if placed facing traffic, visual and aesthetic blight. So the provincial court said, yeah, too bad, buddy. Nope, you can't do it. The majority of the members of the Court of Appeal found that the bylaw infringed on the accused's freedom of expression and was not justifiable under the Charter. The Constitution question in the court queried if the bylaw limited the right guaranteed under the Charter. So it was held that the appeal should be dismissed. In determination whether posting falls within the scope of the Charter, it must first be decided that it constitutes expression, and if so, whether postering on public property is protected under the Charter. Second step requires determining whether the purpose or the effect of the law is to restrict freedom of expression. Postering conveys or attempts to convey a meaning, regardless of whether it constitutes advertising, political speech, or art. First part of the test of the Charter was satisfied. Posting on public property includes utility poles, clearly fosters political and social decision-making, therefore furthers at least one of the values underlying in the Charter. No persuasive distinction exists between using public space for leaflet distribution or using public property for display of posters, so it could be you lost your dog. The question is not whether or how the speaker used the forum, but whether the use of the forum either furthered the values underlying the constitutional protection of freedom of expression. And we know that the bylaw was aimed at the consequences of particular conduct in question and was not tied to the content. On its face, it was content neutral and prohibited all messages from being conveyed in a certain manner in certain places. In other words, you couldn't put posters on the poles. The absolute prohibition of postering on public property, however, prevented the communication of political, cultural, artistic messages and therefore infringed on the Charter. The objective of the bylaw was pressing and substantial, and a total ban was rationally connected to these objectives. By prohibiting posters entirely, litter, aesthetic blight, and associated hazards were avoided. The complete ban on postering, however, did not restrict expression as little as is reasonable. Did not restrict expression as little as reasonably possible. The bylaw extended to trees, all types of poles, and other public property. Worker safety was only affected when posters were attached to wooden utility poles. Traffic safety was affected when the posters were displayed facing roadways. Many alternatives to a complete ban exist. Proportionately between the effects and the objective were not achieved because the benefit of the bylaw was limited where the abrogation of the freedom was total. While the legislative goals were important, they do not warrant a complete denial of the access. So what the Supreme Court basically said is that what the city of and this is where it gets the split here, is the city of Peterborough said you can't put up posters anywhere on public property. Didn't matter if it was a street, didn't matter if it was a tree, didn't matter anything. So what the Supreme Court of Canada says, no, cities and towns, you can't do that. You can say don't put it up on poles, but you can't say don't put it anywhere. Okay, so that's effectively what this case ruled on. We also got this other one here, again, from an issue point of view. Consolidated fast rate. Okay, this is a company. This is a honest to goodness company that lives out in Alberta. So Consolidated Fast Freight operated freight forwarding businesses with branches across Canada. The business consisted of picking up freight in one province, consolidating it into containers, and arranging for transportation to a destination province. The destination that the freight, and distributing that freight to various locations in the province. The business was managed and rates set at a regional or national level. The branch employees did not cross provincial bounds, and third-party carriers transferred the containers between the branches. A union representing the employees at branches in Alberta, Saskatchewan, and Manitoba applied to the Canada Industrial Relations Board for certification. The action, and in this action, the union was applying for a declaration of whether the employees should be federally or provincially certified. Explain the arguments. Okay, so all we're interested in here is explaining the arguments. What is the issue here in this case?
Seems to me like a bunch of technicalities.
Well, let's just throw out the word jurisdiction. Under what jurisdiction do Consolidated Fast Freight, the corporation, probably fall?
Federal?
Yeah, you look, and why would it be federal? Why do you think?
Because they operate in multiple provinces.
They operate across provinces. There's the cross-provincial boundaries type thing, right? And generally, Consolidated Fast Freight would be considered that. Just looking at that, you'd say, seeing they operate in more than one province, it would be considered a federal jurisdiction, because one of the criteria for federal jurisdiction is you operate in multiple provinces, okay? And seeing they're in the business of transferring product back and forth between A and B province, that would indicate. The trick, though, and the fly in the ointment here is we're a union. Now, we're looking at this from a union representation purpose point of view, and we're not interested in the company as much as what union jurisdiction do they fall under. Okay? So the corporation, I think we can say, is probably federal. But the union is saying to them, should we go to the Canada Labour Relations Board, which is for federally regulated employees, or should we go to the provincial? And the reason, why would be potential reason that they'd say we're probably provincial?
Because the employees themselves do not cross the boundaries.
Exactly. And that was the core to this case, is to say, look, the company itself may be considered federal, but the employees themselves are very much working in one province, and they do not transfer between one or the other province. The province of jurisdiction from a union point of view, or the jurisdiction from a union point of view, should be more provincial than anything else. So this ended up in Supreme Court of Canada because it ended up in Supreme Court of Canada. We understand why, because, you know, this is an interesting situation about on what jurisdiction should these employees fall under. So Supreme Court ruled on it here, and it's dealing with constitutional law, division of powers, labor relations. Okay, little verbiage there. The union representing fast freight employees applied to the Alberta Labor Relations Board for a declaration on whether the labor relations of fast freight are subject to provincial or federal regulation. This application was in response to an earlier application by another union to certify them under the Canada Industrial Relations Board at the regional bargaining unit. The board held that fast freight was subject to federal jurisdiction because it was part of a single, indivisible, interprovincial transporting company. The reviewing judge quashed the board's decision and reaffirmed the existing provincial certification order, holding that that absent any physical involvement in the interprovincial carriage of goods, there was insufficient reasons to displace the dominant presumption of provincial jurisdiction over labor relations. Now, keep in mind that labor unless it's specifically laid out as federal, it's provincial. Okay, so it has to be blatantly federal. And here the Court of Appeal said, nah, it's not blatant. So in this particular case, then the employees of fast freight category are subject to provincial jurisdiction. The question whether an undertaking, service, or business is federal one depends on the nature of its operation. An undertaking that performs consolidation and deconsolidation and local pickup and delivery services does not become an interprovincial undertaking simply because it's an integrated national company structure. So the feds came down and said, no, it's provincial. Now, this has big implications for a lot of companies, because if certain portions of their workers are strictly provincial, they would end up falling under that provincial jurisdiction.